Picture this. It is a Tuesday morning in Cranston, Rhode Island. A husband and wife have an argument. Nothing criminal, nothing violent, just a heated disagreement between two people who have been married for decades. A neighbor calls 911 for a wellness check. Police arrive. They speak to the husband outside. He is calm. He is cooperative. He even agrees to go to the hospital voluntarily. But here is where it gets terrifying. While he is gone, while he is not even home, officers convince his wife to let them inside. They go straight to the bedroom and they find two legally owned handguns. They take them, both of them, no warrant, no crime, no charges, just gone. The date was August 20th, 2015. The case eventually reached the highest court in the land. And on May 17th, 2021, the Supreme Court of the United States ruled 9-0. 9-0, every justice, every single one. Liberal, conservative, it didn't matter. They all agreed that what happened to Edward Caniglia was wrong. This affects every gun owner in America, in every single state. And here's what makes this different from everything you've heard before. You are not going to hear this on CNN tonight. You are not going to see a segment on MSNBC breaking this down for you. Cable news had one job: to inform you about decisions that directly impact your constitutional rights. They failed. And it is not an accident. When you win, they go quiet. When the government oversteps, they cheer. When a 9-0 ruling hands gun owners a constitutional victory, they look the other way. That is why this channel exists. We do not answer to advertisers who are scared of the Second Amendment. We do not soften the facts to protect anyone's political agenda. We read the opinions, we break down the language, we tell you exactly what it means for your daily life. This channel was built for people who actually take their rights seriously. Hit subscribe and prove it right now, because in the next few minutes, I am going to show you 3 things that most people will never know. Number 1, why the community caretaking doctrine is constitutionally dead and cannot be used to enter your home. Number 2, exactly how this 9-0 ruling creates a legal firewall around your firearms. Number 3, why the fact that even the most liberal justices on the bench agreed with this decision makes it nearly untouchable. Stay with me. This is going to matter to you. Let's go back to the beginning. The case is Caniglia v. Strom. Edward Caniglia is a retired man in Cranston, Rhode Island, and he had a fight with his wife, Kim. During the argument, he brought out an unloaded handgun, placed it on the table, and said something that frightened her. She left. She spent the night at a motel. The next morning, she called the police because she couldn't reach him by phone. Officers drove to the home. They found Caniglia outside, calm and cooperative. They asked him to go to a hospital for a psychiatric evaluation. He agreed, but only after officers told him they would not take his guns. That was a lie. The moment he left, officers convinced his wife to let them inside. They confiscated both of his legally owned handguns. No warrant, no court order, no due process. When Caniglia was discharged from the hospital that same day, he was told his guns were gone. He sued. The district court sided with the police. The First Circuit Court of Appeals sided with the police. But then Caniglia v. Strom reached the Supreme Court of the United States. And the Supreme Court, in a ruling handed down on May 17, 2021, one-sided with Edward Caniglia, and the vote was 9-0. Justice Clarence Thomas authored the majority opinion. He was joined by Breyer, Sotomayor, Kagan, Gorsuch, Kavanaugh, Barrett, Alito, and Roberts. The key legal language from the opinion says this: the home is first among equals. Let that sink in. The highest court in the land, in the strongest possible terms, said your home sits at the absolute peak of Fourth Amendment protection. The government had been using a doctrine called community caretaking, originally developed for cars, and expanding it to justify warrantless home entry. That expansion is now dead. This ruling connects directly to District of Columbia v. Heller in 2008, which affirmed your individual right to keep firearms in the home for self-defense. It builds on McDonald v. City of Chicago in 2010, which extended Heller protections to every state. And it lays critical groundwork for New York State Rifle and Pistol Association v. Bruin in 2022. This is a chain, a constitutional chain, protecting your rights link by link. Legal disclaimer. Everything I'm sharing today is educational information only. Always consult a licensed firearms attorney for advice specific to your individual situation and your state's laws. The vote was 9-0. Remember that number? We will come back to it. All right, here is where we get practical. Because legal jargon is only useful if you know what it means when you are standing at your front door at 7 a.m. with a police officer on the other side of it. Let me break this down into 5 specific real-world changes that this ruling creates for you personally. Point number 1, the warrantless gun seizure playbook has been torn up. For years, police in certain states used community caretaking as a free pass. They would claim they were just checking in on your well-being. They would use that excuse to enter your home, spot your firearms, and take them. That playbook is gone now. To enter your home and seize your property, law enforcement now needs one of 3 things: your consent, a valid warrant signed by a judge, or a genuine, documented, immediate emergency. We heard you were upset is not an emergency. Your neighbor was worried is not an emergency. A true immediate threat to life, that is an emergency. Everything else requires a warrant. Point number 2, your home is now legally armored. Think of it like this. Imagine you built a fortress around your property. This ruling is the legal equivalent of that fortress. The Supreme Court said, in plain language, that the protections applied to your home under the 4th Amendment are the highest protections available in American law. It's like the Constitution drew a line at your front door and said, everything inside belongs to you and the government needs permission to cross it. That line just got reinforced with 9 concrete pillars, 1 for each justice who voted yes. Point number 3, the community caretaking doctrine is constitutionally confined. Here is some important context. The community caretaking doctrine was originally created in a 1973 case called Caddy v. Dombrowski. That case involved a car on the side of the road, an impounded vehicle, a public space. The court said officers can check a car if they are performing a community caretaking function. Some states, Massachusetts, Rhode Island, New Jersey, and others tried to drag that car side exception all the way into your living room. The Supreme Court just said, absolutely not. Cars are public, homes are private. Those are not the same thing. They never were. Point number 4, due process is now a mandatory step, not an optional one. If the government wants to take your firearms, they have to go through a judge first. They have to present evidence to a court. They have to get a signature on a warrant. Only then can they legally enter your home and take your property. This is how it was always supposed to work. Caniglia just forced states that had been skipping those steps to go back and follow the Constitution. Hit the like button right now. It tells me to keep making content like this. And drop a comment below. I want to know, have police ever attempted a wellness check at your home? Let me know in the comments. Point number 5, this creates a civil liability pathway for gun owners. Here's the part that most channels completely skip, and it is the part that matters most to you personally. If a law enforcement agency violates this ruling, if they enter your home without a warrant under the guise of caretaking and take your firearms, you now have a very powerful civil lawsuit waiting for them. Caniglia gives your attorney a 9-0 Supreme Court ruling to cite. That is not a small thing. That is a nuclear option in a courtroom. Police departments and municipalities are aware of this, which means this ruling does not just protect you after a violation. It actively deters violations before they happen. That is the real power of this decision. Not every state is equally affected by this ruling. Some states were already respecting your 4th Amendment rights. Others were absolutely abusing the community caretaking doctrine. And let me give you the full picture. It's Group 1, most affected states. These were the worst offenders. Rhode Island, obviously, since this is where the case originated. Massachusetts was using community caretaking aggressively, particularly in the Boston metro area. New Jersey had become notorious for wellness check-style entries in gun-owning households. Connecticut and New York were using similar tactics, often tied to licensing disputes or neighbor complaints. If your state is on this list, you need to pay close attention to what I say next. The officers and departments in these states have been operating under policies that are now unconstitutional. Those policies are still on their books in many cases. That means there will be a transition period, and during that transition, you need to know your rights pulled. Group 2, moderately affected states. California, Illinois, and Washington State fall into this category. These states have robust red flag law frameworks that sometimes blurred the line between legal ERPO orders and informal caretaking entries. And this ruling tightens that line significantly. Any entry without a court-ordered warrant or ERPO, even in these states, is now constitutionally suspect. Group 3, minimally affected states. Texas, Florida, Arizona, Georgia, and Tennessee already had strong protections in place. But here's the key for these states. Caniglia now gives gun owners in these states a federal Supreme Court citation to use if anything goes wrong. You now have a 9-0 ruling in your back pocket. No state law can override it. No local ordinance can contradict it. It is the law of the land in all 50 states. Whether you are in Austin, Texas, or Portland, Maine, the ruling applies equally to you. Since this ruling came down, I have seen a tremendous amount of misinformation spreading online, in comment sections, on forums, and even from people who should know better. Let's shut down the myths right now. Myth number 1, this ruling only applies to Rhode Island. Wrong, completely wrong. Here is the truth. When the Supreme Court of the United States issues a ruling, it applies to every jurisdiction in the country. All 50 states, every county, every city. No local judge gets to say, well, we do things differently here. Caniglia v. Strom is binding federal constitutional law. The vote was 9-0. That is as final as it gets. Myth number 2, police can still enter your home if they think you're dangerous. Here is the truth. There is a legal concept called exigent circumstances, and it is real and it still exists. If there is an active, documented, immediate threat to life, a domestic violence situation where someone is being harmed right now, officers can enter, but the key word is immediate, feeling like someone might be upset. That does not qualify. Thinking someone seems unstable based on a neighbor's phone call, not a warrant substitute. The bar for exigent circumstances is high, and Caniglia just made it higher. Myth number 3, this ruling doesn't touch red flag laws. Here is the truth. While Caniglia did not directly strike down red flag laws, it absolutely impacts how they are enforced. States cannot use caretaking as an informal workaround to red flag procedures. If they want your firearms, they need to go through the formal ERPO process, with a court, with evidence, with a judge. No more informal entries dressed up as wellness checks. Myth number 4, since liberal justices voted yes, it won't hold up. Here is the truth. The vote was 9-0. Ruth Bader Ginsburg, arguably the most liberal justice in recent Supreme Court history, would have agreed with this. Sotomayor signed it, Kagan signed it. When both wings of the court agree on something unanimously, it sends a message to lower courts that there is no wiggle room here. This ruling is as durable as any the court has ever produced. Now that we've cleared all of that up, here is the part that honestly keeps me up at night. I want you to understand something fundamental about how government power works. When the Supreme Court takes power away from the government does not just accept it. They regroup, they rename, they redesign it, and they try again. It has already started. Right now, in state legislatures across the country, attorneys and lawmakers are drafting workarounds to Caniglia. And let me tell you exactly what those workarounds look like so you can recognize them. Workaround number 1, the public health emergency framing. Some states are exploring language that would categorize certain mental health situations as public health emergencies. The argument is that public health emergencies give the government expanded access powers. Watch for that language in your state legislature. It is coming. Workaround number 2, renamed licensing requirements. New York and Massachusetts are already discussing eligibility certificates, essentially a licensing scheme where your continued right to possess firearms is tied to annual eligibility reviews. Miss a review, get flagged in a database, and suddenly your license is administratively suspended. Then officers show up, not for a wellness check, but to verify your current eligibility status. Same entry, different label. Workaround number 3, mandatory storage inspections. California has already floated legislation that would require safe storage inspections for households with firearms. The theory is that if you agreed to safe storage as part of a licensing requirement, you consented in advance to inspections. That is a creative and dangerous piece of legal architecture. Workaround number 4, automatic ERPO triggering. Some jurisdictions are working to make the ERPO process more streamlined, which in practice means lower evidentiary standards and faster turnaround. Right now, tonight, someone is sitting in a government office drafting legislation to bring the caretaking concept back under a new name. They are patient, they are well-funded, and they do not sleep. That is why you cannot afford to either. Subscribe to this channel right now and turn on the notification bell. I will track every single state response to this ruling. I will cover every piece of legislation that tries to walk back Caniglia, and I will alert you the moment something changes in your state. This is too important to miss. You now have more power than you did before this video started. But power only matters if you use it correctly. Here is your specific, actionable plan starting tonight. Step number 1, learn the ruling by name. You need to be able to say Caniglia v. Strom, Supreme Court, May 17, 2021, 9 to 0 inches without hesitation. Write it down, put it in your phone. The moment you cite a specific Supreme Court case by name in a conversation with law enforcement, the entire tone of that interaction changes. Step number 2, never consent to a search, ever. I cannot say this clearly enough. If an officer asks to come inside, your answer is polite and firm. I do not consent to a search of my home. You do not need to be rude. You do not need to be aggressive. You just need to say those words. If they have a warrant, they will show it. If they do not, they must. Step number 3, install cameras and document everything. Cameras at your doors and entryways are not paranoia. They are evidence preservation. If an officer attempts a warrantless entry, you want that on video. That footage could be the difference between a successful civil lawsuit and your word against theirs. Step number 4, know your state's ERPO laws cold. If your state has red flag laws, California, Illinois, New York, New Jersey, Maryland, Colorado, and others, you need to know exactly what the threshold is for an ERPO filing. Who can file? What evidence do they need? How quickly can a judge sign one? Knowing the process means you can prepare for it and challenge it if it's misused. Step number 5, have a firearms attorney on speed dial. Not an accident attorney, not a family lawyer, a licensed firearms attorney in your state who knows Second and Fourth Amendment law. If your guns are ever seized, time matters. Every hour that passes makes recovery harder. Step number 6, support the organizations litigating these cases. The Firearms Policy Coalition, Gun Owners of America, and the Second Amendment Foundation are actively filing cases that build on rulings like Caniglia. Your membership and donations fund the legal battles that protect your rights. Step number 7, share this information immediately. Most gun owners have no idea this ruling exists. That is not their fault because no one told them. You now have that information. Pass it on. Let's bring this home with the 3 things that matter most. Number 1, the Supreme Court ruled 9 to 0 in Caniglia v. Strom. That vote 9 to 0 is as powerful as any constitutional protection can get. No justice dissented. No justice wrote a limiting opinion. Your home is the highest protected space under the Fourth Amendment. Number 2, community caretaking is dead as a justification for warrantless home entry. Officers cannot enter your home because they feel like you might need help. They need a warrant, period, full stop. Number 3, the states are already working on workarounds. That means your awareness, your preparation, and your engagement right now tonight matters. I want to put this in historical context for you. Heller in 2008 confirmed you have the right to own a firearm. McDonald in 2010 confirmed that right exists in every state. Bruin in 2022 confirmed your right to carry outside the home. And Caniglia says that inside your home, the place where your family sleeps, the place where your firearms are stored for protection, the government cannot enter without permission. Together, these 4 rulings are building a constitutional fortress around gun owners that has not existed at any point in American legal history. But rights come with responsibility. The responsibility to know them, to exercise them, to defend them. Drop a comment right now and tell me what surprised you most about today's video. Was it the 9-0 vote? Was it the workarounds? Was it how simple your action plan actually is? I read every single comment. Share this video with every gun owner you know. Most of them have no idea this happened. You are the messenger now. In our next video, we are going deep on New York's new attempt to ban carry in public parks and transit and why it is headed straight back to the Supreme Court. That is a video you absolutely cannot miss. Stay informed, stay armed, stay free. Subscribe, and I will see you in the next one.